Jim Rubens here, War Room Director for the Federal Fiscal Sustainability Foundation. Personal background: I'm a small-scale investor, former New Hampshire state senator, and a full-time amending activist. Now, no one can predict exactly when, but we're no more than a few years from a national fiscal meltdown. When the federal debt bomb explodes, we'll all pay the price in punishing inflation, high interest rates, and permanent economic stagnation. To fix this, for decades we've tried and failed at electing better candidates, changing party control, and various statutory fixes like Gramm-Rudman or PAYGO. There is one remaining politically viable path to save our nation from Washington's bottomless addiction to debt. The states must litigate against Congress to enforce their power under Article 5 of the U.S. Constitution to propose an amendment which caps national debt. Whatever your favored party, only an amendment can bind both current and future Congresses. Our Constitution's framers had the extraordinary foresight to recognize that Congress could, just like today, become dangerously self-interested and would block needed amendments. Article 5 therefore provides equal power to the states to propose amendments should two-thirds of the states agree. So back in 1979, with deficit spending causing painful double-digit inflation, 39 states had submitted valid Article 5 fiscal responsibility applications to Congress. These state applications triggered the non-discretionary, binding obligation upon Congress to call a convention for proposing amendments, in the words of Article 5, in this case limited to the subject of federal fiscal responsibility. But since 1979 and right through today, Congress has ignored these applications, effectively voiding the bedrock of federalism, equal state power to propose amendments. For this reason, several states' attorneys general are now preparing litigation against Congress to enforce state power to propose a fiscal responsibility amendment. The chief concern we hear is that the state-led amending path will be a first in U.S. history, true, and therefore a procedural dice roll. Not so. Visit the National Federalism Commission's website and you'll see that since 2017, the state's been doing very detailed planning for an amending convention. And convention delegates selected by the states cannot run away because the Supreme Court ruled 9-zip in 2020 that the state legislatures may remove and replace any delegate attempting to stray, in this case, from the fiscal responsibility subject matter. Please visit us at ffsf.us if you want to get into the weeds on the legal issues. Bottom line, here's the ironclad guarantee that the process is safe. Any amendment proposed by the states, just like those proposed by Congress, takes effect only if ratified by the very high bar of 38 states. This means that any proposed amendment must be crafted to win broad public support in both red and blue states. Any amendment attempting to tamper with the Bill of Rights or Social Security or to impose sudden or draconian hardships on any segment of our population is dead on arrival. Over U.S. history, constitutional amendments have repeatedly been the pathway to national consensus around our most difficult political problems. At the Federal Fiscal Sustainability Foundation, we are confident that the states and the American people will rise once again to meet this historic challenge and opportunity. Be in touch with us or your state attorney general if you're ready to grapple with the reality that Congress will not ever shake its debt addiction until the Constitution requires it, and that the states must take the lead. Thank you.